All right, well, I think we'll go ahead and get started. Good afternoon, everyone. Welcome. Thank you for joining us. Thank you, of course, to our sponsors. My name is Dan Lindsay. I am the Chief Litigation Officer at Legal Aid Chicago. Welcome to our fourth installment of our series, Legal Aid Matters. Today's topic is consumer debt, and in particular, the Early Resolution Program. This is a new program that our consumer practice group took on last year during the pandemic, and really as a result of and to address some of the consumer debt problems of the pandemic. And so you're going to be hearing about this program today from a number of our staff. So at this point, I would like to turn it over to the director of our consumer practice group, Einat Margalit.
Hi. My name's Einat Margalit, and I am director of the Consumer Practice Group. The focus of consumer is retaining assets for our clients. A primary focus of the practice group is sustainable home ownership, a major vehicle for building wealth and stability in underserved and minority communities. We also accept cases where we can help protect income, a subsidized housing voucher, vehicles, and uninterrupted utilities. All factors whose loss can destabilize a household's financial future. Typically, we provide full representation in our cases, spending months and frequently years to achieve a result. In late 2020, we were asked to participate in the Early Resolution Program. The Early Resolution Program is funded through Cook County in response to the COVID-19 pandemic and the economic crisis created by the pandemic. Early resolution was created with the goal of allowing every single unrepresented person sued for eviction or consumer debt the opportunity to speak to a legal aid attorney before their case proceeds. We are not the only legal aid organization taking on this role. We share the responsibility with other legal aid organizations across Cook County. There are two fields of practice in the Early Resolution Program: eviction, handled by our housing practice group, and consumer debt, handled by consumer and the subject of this presentation. Consumer debt is typically credit card, personal or payday loan debt, auto loan debt, or a landlord suing for rental debt, some medical debt. A landlord suing for rental debt, but not eviction. For example, if the tenant has already left the premises, the property. As we will discuss, we are able to give our clients the information they need to allow them to make an informed decision about their case or provide brief services to help them achieve their desired result in the case. Through the Early Resolution Program, we have been exposed to a much larger number of consumer debt cases than before and have been informed by our findings in stocking our toolbox to help other debtors. There are 4 advocates on the Early Resolution team. Myself, on a better hair day, Ernie Gordon, Dan Hawley, and Emma Lubitch. Dan Schneider is an Early Resolution team alum who now works for Legal Action Chicago and is also participating in this presentation. So thank you for joining us. And to continue with the presentation, I would like to introduce Ernie Gordon, our staff attorney.
Thank you, Einat. My name is Ernie Gordon, and I am the Early Resolution Program staff attorney in the Consumer Practice Group at Legal Aid Chicago. When we first get a case, either through an in-court referral or through a client calling the hotline, we initially assess the client's situation by determining if they are collectible. If a client is collectible, that means that a creditor can collect on a judgment entered in their favor against the debtor. We ask the following questions to assess collectibility. Is the client's income under the garnishable wage limit? Are there pre-existing liens on their home or car? And are there any other assets that the client owns? If a client is below the garnishable threshold and owns no non-exempt assets, the client is what we refer to as uncollectible or judgment proof. This impacts what services we can provide to the client. One of the most common ways that creditors collect on a judgment is through wage garnishment. The most an employer can withhold from a consumer's wages for a creditor is 15% of the consumer's income, but an employer is additionally limited and unable to withhold an amount that leaves the consumer with less than 45 times the state minimum wage. The state minimum wage is currently $12 an hour, and this is what sets the garnishable threshold limit at $540 weekly net income, which will continue to increase along with the Illinois state minimum wage throughout 2025. Illinois consumers also benefit from certain statutory exemptions that apply to not only different forms of income, but assets that they may own. These exemptions are important to take note of because exempt money and property cannot legally be taken to satisfy a judgment. In addition to net wages below the garnishability threshold, there are other types of income that are also exempt from collections, like Social Security benefits, including Social Security insurance and disability insurance, unemployment benefits, workers' compensation, and disability insurance. The other ways that creditors can collect on a judgment is through placing a lien on personal or real property. This is also subject to limitations. Personal property has two exemptions: the automobile exemption, which can protect up to $2,400 in equity in a motor vehicle, the wild card exemption, which is $4,000 worth of equity that can be applied to any asset and can be stacked with other exemptions, or could apply to another otherwise non-exempt asset like a bank account with under $4,000. Assets in a retirement plan and public employee pension plan are also exempt from collections. Real property is also subject to limitations, such as the homestead exemption, which can protect up to $15,000 of equity in a residence, including a home, mobile home, condominium, or building or lot used as a residence. Proceeds of a sale of a home 1 year after the date of sale are also exempt. Next, we can talk about the core services provided by the clients or to the clients in the early resolution program. We provide a lot of advice on consumer rights, options, and risks in a consumer debt action. Advice may be the primary service provided if a client is uncollectible. Then we can advise them on the implications of a judgment and explain collectability, often referring for them to return and call back if assets or wages are threatened. Also, if a client wants to apply for a hardship dismissal, which I'll talk about in a moment, but they're not particularly a good candidate for one, we can provide advice and materials to assist in the pursuit of that hardship request. If the client is a higher income household and they want to negotiate a settlement in their case, we can provide them with advice and materials to do so. A hardship dismissal is when a client requests a dismissal of the case and they have to be uncollectible plus. That means that they're requesting a dismissal based on a documented permanent financial hardship, typically accompanied with an additional hardship, such as suffering a serious illness or helping take care of a sick family member. Hardship dismissals are not a right or a guaranteed solution that is open to consumers, as they are subject to the creditor plaintiff's discretion in whether to grant or not. We also work on settlement negotiations, which can take the form of a payment plan or a lump sum payment. We can negotiate with opposing counsel on behalf of collectible low-income consumers, either by paying a substantial but reduced amount of the amount sought, or by creating a payment plan that the consumer can afford, while again, also seeking a reduction in the overall amount sought. We can also discuss representation with clients. The larger consumer practice group can accept to defend the case on its merits. We can refer to another practice group internally if the issue falls within the scope of the other practice groups. For example, if a housing issue pops up, then we can refer to our housing group. If there is an unemployment issue, we can send a referral to our immigrants and workers' right practice group. And then we can also refer to a private attorney if it's a consumer debt issue that otherwise falls outside of the scope of the program's guidelines. I would like to pass off the stage to Emma Lubich, one of the early resolution program paralegals here at Legal Aid Chicago.
Hi all. So as Ernie said, my name is Emma Lubich. I'm a paralegal in the consumer practice group. I will be talking about some notable numbers from the early resolution program. So in total, we have advised, just around 650 clients. So this number includes both clients that we've provided services to, so cases that are closed, as well as cases that are ongoing. We have provided brief service to over 300 people thus far. So this group is made up of individuals who are uncollectible, so meaning that they don't have garnishable wages or assets at risk, as well as having no capacity to settle. So this also includes high income individuals who we're able to advise on how to strategically negotiate settlements directly with opposing counsel. We have now saved over $412,000 for clients we've negotiated settlements and dismissals for. We have negotiated around 200 standard settlements. And the median settlement that we've negotiated for clients is around $60 per month. We've taken 30 cases for full representation. So that means that they come to us through the early resolution program and then are taken for extended representation by one of the consumer practice attorneys. We've negotiated around 30 hardship dismissals. So these are individuals who, as Ernie said, are facing particularly difficult financial circumstances, but this is often coupled with something else. So something like a disability or a medical hardship. We've gotten 10 cases dismissed for fraud or identity theft. And this last one has to do with how clients are served. So we've had several individuals come to us that have received what we'd call like sewer service. So this essentially means that someone was improperly served or not served at all. In some of the more egregious cases, we saw process servers claiming to have served an individual who didn't even exist in the client's household. And this is something that Dan Schneider will be discussing a little bit more in this next section. Thank you.
Thanks for the handoff, Emma. Hey, everybody. As stated, my name is Dan Schneider. I am a staff attorney at now Legal Action Chicago, which is a separate organization from Legal Aid Chicago that, among other things, works on advocacy and class action litigation. But for about a year before I joined Legal Action, I was the first staff attorney working on the early resolution program's consumer debt side, helping to implement it and dealing with the first round of hundreds of cases that we saw come through the program. And what I want to talk to you are just some of the common themes and ideas that I observed in my first year helping to implement this program. And right off the bat, I want to get to the dynamics involved in trying to resolve one of these consumer debt cases. And I'll start off by saying, not every case that comes through ERP to our agency can be resolved. There are just some situations where, because of the amount of debt at issue and what money a person does or rather does not have available, you just can't work out a deal with a creditor. That said, we were really pleased to find that there were a lot of situations where, with just a little bit of advice and a little bit of effort, people were actually able to get their claims resolved and settled, as Emma just described. We had a lot of success there. And although it's listed as the last factor that can, sort of determine what leverage exists in negotiating a consumer debt that's on this list, I want to note that having that limited representation available was really important to our clients. Just the simple fact of having an advocate available who can look at the complaint, look at the exhibits, look at the claims asserted, and importantly, talk to a person about their financial situation and what their goals are, can actually provide a massive benefit to them and get them to a point where they're able to actually work out a deal with the creditor, either through us or on their own. But there are some more tangible factors at play too. For example, Emma mentioned sewer service, which I'm going to talk a little bit more on the next slide. But certainly, if someone was improperly served, or even if someone may have lied in a service affidavit, that can affect a creditor's willingness to settle a lawsuit. Of course, someone might have strong defenses to their claim. There are debt buyers, that is, companies that purchase debt often for pennies on the dollar and then sue on it as their primary business model. that operate pretty frequently in Cook County and are frequent filers in the circuit court. Sometimes those companies have issues coming up with the documents proving that they're the legal owners of this debt. And of course, many of the people sued over these $1,000, $2,000, $5,000 debts have no idea what the chain of title is or even how to assert a defense around it. But by coming to our agency through ERP, they're able to learn more about their case and maybe leverage the absence of the needed documentation to get a better deal. That is a lower monthly payment or even a reduction of the balance that the creditor wants them to pay back on the debt. In some cases, there might even be counterclaims depending on, what happened with the debt. Perhaps the collector engaged in, unfair practices or conduct that's illegal under the Fair Debt Collection Practices Act. Automobile repossession is also an area where this comes up a lot. Illinois has very specific rules about what has to happen when someone defaults on an auto loan and has their car repossessed. And if those rules aren't followed to a T, someone may have affirmative defenses or counterclaims that they can bring. But at the end of the day, the biggest and most common factor in determining whether or not there might be some leverage to convince a debt collector to accept less than is claimed to be owed on a debt or a much smaller monthly payment is whether or not anyone simply has the ability to pay. You heard my colleague Ernie talk about some of the exemptions under Illinois law, and we have lots of people who came to the agency during my year in ERP who just were not going to be collected on. They weren't earning enough money. Many of them were elderly and living on fixed incomes or had sources of incomes that you can collect on, like Social Security, and still wanted to resolve their debts anyway. Well, coming to a debt collector with that package of information and explaining that, no matter what, the odds of the collector ever recovering anything on the debt, whether or not they get a judgment, is virtually zero. That can often lead them to put together a deal that allows the person to pay the debt back in a more reasonable amount of time that's within their budget, or even just resolve it with a smaller lump sum payment. Now, I mentioned sewer service among some of these factors, and I will get to in a second, but I really just first want to emphasize that, in working in this world, the thing that became very clear very quickly once we got the ERP up and running was that, consumer debt collection is an industry that operates on volume. Many of the entities involved, both the creditors themselves, the debt buyers, and even the firms that represent them, operate on volume. They're not filing 1 or 2 or 10 cases at a time in our circuit courts. They're filing many, many, many cases at a time, dozens, hundreds. I have not counted the exact number because I have other things going on in my life, but suffice it to say, there are just countless debt cases pending at any given time in Cook County and the other counties, often in small claims court. And for consumers, what this means is that because they're dealing with an industry that operates on volume, anything that can delay or put collection at risk of not happening increases its costs and makes it a little more likely they'll be able to work something out with the creditor that's within their means to pay back. And collectability, like I discussed, whether someone can pay it back, it really does play a role. But at the end of the day, you may need something more than just, what you consider a good offer to get these cases done. At the end of the day, the things that can affect the leverage involved really do come into play, including how much money someone has, whether they have defenses or counterclaims, and as I mentioned a few times now, the way that they've been served may actually come into play. You heard my colleague mention this earlier, and me mention a couple times that, sewer service or just bad service is something that happens not infrequently within this world. Again, it could just be due to volume, trying to, keep costs down relative to the amount of debt at issue, or the fact that, in the category of defendants at issue here, this tends to be a lower income population, a population that is sometimes more transient. Whatever the case may be, it is often an issue that people are served just improperly. I mean, without citing, the specific cases. I mean, in my time in ERP, I saw instances of process servers tossing complaints into people's open windows, documents left at the doorstep that where an affidavit was later filed saying they handed it to someone in person. A process server claiming in an affidavit they served a roommate when the person doesn't even have a roommate. This stuff is not uncommon. And for any practitioners out there who work in this world, you do want to keep in mind that if a creditor files a false service affidavit in the case, the process server and law firm they're working with may actually be subject to liability under the Fair Debt Collection Practices Act, which prohibits, unfair and, various practices in collecting on consumer debts. There are a few court decisions in the Northern District of Illinois, at least, that have addressed this. And at least for now, the rule seems to be that filing an affidavit saying that you served someone when you actually haven't can be a form of a debt collection practice that removes debt collection firms and process servers from some of the exemptions the FDCPA provides, and can actually subject them to liability. That is, the courts just say, hey, if you're filing affidavits falsely claiming you've served someone when you haven't in order to collect on a judgment or get a quick default judgment, that itself is an illegal practice under the FDCPA. And while in most of these cases, you probably wouldn't be able to hold the creditor accountable directly unless they had some knowledge of or role in, serving process or how that's conducted, it is something that overall could potentially lead to the creditor decide, what, this is just too messy. Perhaps we just want to try and resolve this in a way that is a little more favorable or within the means of the person we're trying to collect on here. So, like I said at the outset, I'm no longer at Legal Aid. I'm no longer with ERP. I'm now working at Legal Action Chicago. But my year working on the early resolution program really, really taught me a lot about, the ongoing trends in the debt collection space here in Cook County and more broadly. I mean, just at minimum, because the sheer number of matters that are referred to us, you get a very, very quick and good overview of what kinds of things are happening. Just by a quick way of example, so I can turn it over to my colleague, Dan Hawley. One issue we saw come up pretty frequently in ERP were issues regarding the use of kill switches in vehicles. I mentioned auto repossession is a pretty common kind of lawsuit we saw in ERP. And what we noticed over the course of my, maybe my first 6 months working on the early resolution program was there were auto lenders in Cook County who had installed kill switches in vehicles. These are starter interrupter devices that actually can be triggered remotely and prevent the car from starting. And they're used by some creditors in order to induce people to make payments on their loans and perhaps to disable the cars to make it easier to repossess them. But we discovered was there was a company here in Cook County that actually was installing these kill switches, activating them when people, didn't make payments on their loans, and then would just leave them on indefinitely, not for a day or a week or a month, but years even, and that are still activated to this day. So without getting too deep into the details, suffice it to say, this broader view of what is going on in the auto debt collection space has actually informed some of the work I've been doing at Legal Action Chicago. And if you stay tuned in the future, you might see some, work or advocacy that's possible we could be doing in that area. So now I want to just, before I pass it off to my colleague, Mr. Hawley, I want to just note again that the CLE code for this presentation is 545TH6. Again, that's 545, capital T, capital H6. So remember to save and put in that code if you want to get the credit for this one. And with that, I will turn it over to Daniel Hawley.
Perfect. Thanks, Dan. I appreciate it. Well, my name is Daniel Hawley, and I'm one of the Early Resolution Program paralegals. I'm going to discuss some common facts and results that we see in the program. And we're also going to get a bit interactive here. So now that you have the basic contours of the early resolution program down, I'm going to ask some poll questions after each case so that you can step into the shoes of an ERP advocate. So after I present the basic facts, I'll ask you how you would advise the client. So you can keep that in mind as we read the facts off. Okay, so first, we have Mr. K, who was sued for just under $5,000 from an outstanding balance on a used car that he purchased for about $4,000 at almost 35% interest. The car stopped working shortly after he bought it, but just outside of the 15-day statutory used car warranty window. Mr. K offered to have the car repossessed, but was told to continue making payments. He continued, at which point he could no longer afford to pay. And on top of it all, Mr. K's house burned down. And when he's not working, he's taking care of his disabled sister and elderly father. So how would you advise Mr. K? Do you think he has an affirmative defense? Should we try to negotiate a settlement? Should we request a hardship dismissal from opposing counsel? Or should we just give him advice? Okay, it looks like most folks thought we should go for a hardship dismissal. That is, in fact, what we did try. Unfortunately, Mr. K's hardship dismissal was denied. But we found that oftentimes hardship factors alone aren't sufficient for being granted a dismissal. Most often clients need a combination of hardship factors and being uncollectible for the foreseeable future. Still, the hardship request was not for nothing. We were able to negotiate a lump sum or one-time payment of $2,400 to dismiss the case, which is nearly a 50% reduction on a case without a clear legal defense, while also avoiding hundreds of dollars in court costs. Next, we have Ms. A, who owed $4,500 in damages after moving out of a mobile home park where she feared for the safety of her and her son. I think this case is a good example of the benefits of the paralegal attorney structure, because after identifying a potential issue with the rent ledger and lease agreement, the paralegal pulled in an early resolution program attorney who researched the Mobile Home Landlord and Tenants' Rights Act to find the two relevant legal standards: a written notice requirement unless the tenant was in imminent danger, and a 50-day window for the landlord to provide an itemized list of damages. We felt that both of these standards were likely favorable to our client, but she didn't have documented evidence. So with those facts in mind, we ask again, how would you advise Ms. A? Okay, so it looks like some folks thought that go for the affirmative defense, which was definitely maybe on the table, and most thought negotiate a settlement. We did think that because her chances at trial were ambiguous, we set out to negotiate a favorable settlement. And it was a success. Ultimately, our client wasn't willing to risk a trial and was able to settle for an amount just above what she agreed she owed, saving over $3,000 in balance and another $500 in court costs. Like Mr. K's hardship dismissal request and subsequent settlement, even though Ms. A did not go to trial, the research relayed to opposing counsel was likely a key factor in winning a very favorable settlement. And as you can see, Ms. A was happy about the result. This message was from a text we received shortly after resolving her case. So we also have Ms. M, who had incurred just over $5,000 in credit card debt because she had no income besides SNAP benefits. She's had multiple impediments to working, including 60 days of bed rest with long COVID. But she originally stopped working after her car broke down. Without a car, her commute would have been 2 hours each way. This was untenable, especially for wages as low as $11.50 an hour. Finally, the original creditor sold her debt, so this lawsuit was brought by a debt buyer. So would you try a debt buyer defense or an affirmative defense? Would you settle, request a hardship dismissal, or just advise? Okay, almost everybody thought we should go for a hardship dismissal. That was what we tried. And hooray, a successful hardship dismissal. Ms. M's case was resolved without paying a dime, and she did not have to participate in the case further. In addition to clearing her consumer debt, we referred Ms. M to the Illinois Rental Assistance Program to help her catch up on past due rent. And I think this is a good example of how the Early Resolution Program can channel intersecting issues through multiple avenues of support and resourcing. Finally, we have Ms. Y, who came to ERP with a $1,000 debt on income of just $1,500 a month. The size of the debt is smaller than many of our typical cases. It's certainly a very large percentage of Ms. Y's budget. As we reviewed the case, we identified several issues. First, Ms. Y informed us that she had already filed identity theft complaints with the Consumer Financial Protection Bureau, the Federal Trade Commission, and the Illinois Attorney General. Second, as we examined the complaint, we found 5 previous transfers from debt buyer to debt buyer and so on. And when we discussed how Ms. Y was served the summons, we found a discrepancy between her account and the affidavit of service filed by opposing counsel. Here was an example of the sewer service alluded to earlier by Emma and Dan. In fact, Ms. Y lives alone and sent us a doorbell camera video of the process server leaving the summons at the front door and walking away. So how would you advise Ms. Y? Yes, most people said we should claim an affirmative defense here, and that is what we decided to pursue. But first, we made clear that Ms. Y should not file an appearance in this case in order to preserve her claim of sewer service. We will be taking Ms. Y as a client for extended representation, pursuing debt buyer and identity theft defenses. And with that, I will turn it back over to Dan Lindsay.
Thank you, Dan. And the other Dan, whose names I like because I'm named Dan. But you don't have to be a Dan to work in the Early Resolution Program because we also have a Nod and Emma. And all of you did a fine job and gave a lot of good, interesting information, and were very efficient So we're going to have some time to do Q&A in a few minutes. So if you have questions in mind, thinking of questions, feel free to put them in the Q&A function, and we'll return to those in just a couple of minutes. First, I want to importantly make a few points about how you can help us. Obviously, we are always very much dependent upon the generosity of our donors, and so donating in any form is much appreciated. As you probably all know by now, we have a luncheon next week, and I'm told that today is actually the last day to buy tickets for the luncheon. So if you're considering doing that and haven't done so yet, please look into that. We hope to see as many of you as possible next week. As you'll see, we also have an ambassadors board where you can join and be active, whether you're an attorney or a young professional who's not an attorney. As long as you like to network and join forces to help us and raise money and support us in whatever ways possible, we'd love to have you look into joining that. And then we have other volunteer opportunities. We have a lot of in-house volunteers. We have volunteers who will work on one case for us, or a series of cases, or will participate in clinics at help desk. So a lot of different opportunities. So please check out our website. The URL is there. Look at our website, Legal Aid Chicago, and you can find out more about all those different opportunities. So now let us turn back to the substance of the day, the Early Resolution Program and consumer debt, and look at some of the questions that we've gotten. So I think a couple were answered already in writing, but I may raise them anyways, just to make sure that they get aired for everyone, and there might be a little more detail or discussion. I know that there were a few questions, for instance, that sort of probed more deeply into the issue of exempt income or assets. So, Einat, I think I'll turn to you, and you can either answer these questions, or if you want to farm them out to others in the program for them to field. But 3 categories of things that were asked about. Well, I'll just give them to you one at a time. So first of all, alimony. It was asked whether alimony maintenance, it's also called, you got to answer that, as well as child support. Are those kind of income or assets exempt, or could they be collected by a debt collector?
Sorry, I am now unmuted. Domestic support payments are exempt from collection. So they cannot be garnished or attached by a judgment creditor.
Well, I'm going to ask you a follow-up question. If they come as income, or they're identified as domestic support payments, as you just said, they're exempt. What do you deal with the issue of somebody that maybe has a bank account and there's just, say, $2,000 or $3,000 or more than the $4,000 exemption limit, money sitting in there, and it all came from domestic support, but it's kind of sitting there for a while. Does that become a problem, or is it still exempt, or how does that work?
It's still exempt if the funds can be identified as being paid for domestic support. They're still exempt. If the funds are intermingled, proving that can be more difficult. So we would encourage people not to intermingle those exempt funds with non-exempt funds.
Got it. Another category was life insurance proceeds. Someone asked about those, whether they're exempt or not.
So in Illinois, life insurance proceeds are exempt. There are some exceptions, which I don't know the twists and turns of them, but the proceeds are exempt.
Great, thanks. And then there was another question that was related about money coming through inheritance. So just general money or different types of money, stocks, bonds, things like that, coming to somebody through inheritance.
Yeah, generally not exempt. depending on the source, but they're generally not exempt. But there is actually a judicial decision about inherited inherited pension fund, where once it had been inherited by the heir, it became non-exempt, whereas before the person had passed, they were exempt funds. I will say that just to dispel any confusion, you can have child support payments can be collected from someone's paycheck, but that is the person that is paying the child support, not the recipient of the child support. So,
Got it. Thanks. So there's another question about whether the consumer practice group has ever found it useful to refer a client to or to file a complaint with a Better Business Bureau to investigate, negotiate, or resolve a debt. So if you want to take that one.
sure. We don't typically refer to the Better Business Bureau, but we do refer clients to file a complaint with the Illinois Attorney General. They have a robust consumer practice, and they do pursue lawsuits against companies that are violating Illinois' consumer laws. So the complaints are sort of aggregated so that they can see trends and pick out bad actors.
And sort of a follow-up, do you, however, use any of the information from the Better Business Bureau or look to their data to help in any way in analyzing parties or cases or facts?
Yeah, we do research. We do research companies by looking up their Better Business Bureau scores and complaints that you can see. If there are some visible complaints, we would look at those to see if there is a pattern and this has happened to other people.
Got it. Back and forth a little bit here. Well, someone was asking about the sort of fraud and ID theft cases that have come in through the early resolution program. It's just sort of what happened to them. If you could talk a little bit more about them.
Yeah, I think I can refer that to one of my team. Maybe Dan, Holly. Do you think you could respond to how the identity theft cases play out?
Yeah, so we typically have the client fill out an identity theft affidavit that will then send to the opposing counsel so that they're aware of the identity theft claim. I think that, we could talk about a few of the different ways they play out. I think some of the ones that we're seeing are still in the process. My understanding is that we've had cases where once we kind of make the other party aware that there's an identity theft claim, they might be willing to drop it or settle for a far smaller amount. Do you feel like that's fair?
Yeah.
And is there a particular form or paperwork that gets used now when a defendant is alleging that they have been a victim of identity theft in these cases?
Yeah, you can find it on the Illinois Attorney General's website.
Got it. Well, and we have another question about the Illinois Attorney General. This questioner asks whether there's any recourse for cases if the AG gets involved, if it's out-of-state creditors, or can they only deal with in-state creditors?
I think if they're doing business in Illinois, they can go after them. I don't think they're limited to Illinois corporations.
Got it. Another person asks, does publicity or PR ever come into play in these cases? It seems like some of them are issues where the public could generally agree these violations are not, or collecting are not in the public interest, and the violations are not. Do we ever threaten to go to the press or go to the press on any of these kinds of cases?
We haven't on the early resolution program cases, but it is something that Legal Aid Chicago does generally. sometimes take up to advertise the what's going on in our clients' lives. And
So here's a question about the asset exemption specifically. If the equity is greater than the exemption amount, is the consumer required to sell the asset or otherwise pay the debt? How does it
Yeah.
work applying the exemption?
maybe Dan Schneider or Ernie. Yeah, no, Ernie, you popped up. Now you have to answer it.
I was going to say that impacts a topic that we didn't discuss that much today, which is bankruptcy, about having to sell an asset, but this is about putting a lien on an asset and the ability for a creditor to do that. And I didn't explain it as much as I would have liked, but the wild card exemption that I was mentioning earlier, the $4,000 in equity and assets that you can protect, and how I said that could stack with the automobile exemption, for example, the $2,400 exemption. Those two can stack together to protect equity in an automobile up to $4,000 or up to $6,400 total. So this analysis was, again, more about placing a lien on something rather than being required to sell the asset. And then the lien would be satisfied once the asset is sold from the proceeds of the sale.
Thanks. Another question is a little different. The questioner asks, if somebody's not in active collection, there's no actual case, but just they have bad credit, one or more debts hanging over their head, what kind of advice would you give them? Where would you refer them? Housing counselor, financial counselor, are there places they can go to help try to fix their credit? Sort of do's and don'ts in that general area.
We do have some financial counselors that we refer people to. We also will give some general advice to people, struggling with debt, which is to focus on those specific debts where something can be taken away, your rent, your utilities, but also those to make sure that you are buying food, that sort of unsecured credit card debt may not be the best place to be, putting forward to the most of your sort of sparse resources, and that you should be focusing on a mortgage, a car, your utilities, so those types of debt.
Can you talk a little bit about the statute of limitations on these cases or different types of cases and like where those come from?
Sure. I'd like to give someone else an opportunity to answer. Maybe Dan Schneider, do you want to talk about some statute of limitations? You feel it? Sure.
Yeah, sure. So the statute of limitations for debts can vary a little bit depending on, the nature of the claim and the kind of debt you're talking about. There's a 10-year statute of limitations for written contracts in Illinois, and then a 5-year statute of limitations for oral or implied contracts. And there is also a statute of limitations for revolving debt and credit accounts. What this all means is that, when, we've got a case through ERP, the very first thing we would typically do is look and see what are the actual documents that have been provided that help us understand what kind of a claim this is. Usually in the complaint, it's pretty obvious. It will be alleged that there's an oral contract or an implied contract, or there will actually just be the contract attached to the complaint. And that'll make it clear, what kind of statute of limitations might apply. Occasionally, we also saw issues, with the debts that came from out of state, debts where there might actually be another state statute of limitations apply. I remember there's one case where we had this issue come up where there was a contract where a creditor had actually tried to apply a statute of limitations where there was a wax seal involved. For all you lawyers, remember wax seals from your first year of law school and contracts. There was a statute, I think, in Rhode Island that allowed you to apply one and extend the statute of limitations by about 10 years. So that's all to really say. It can vary based on the nature and the type of claim being pursued. And then, of course, there are also statute of limitations issues that come up with reviving a judgment in terms of, someone's gotten a consumer debt judgment entered against them, how long the creditor has to actually go ahead and enforce that before, the law has just, we've decided that, it's been too long, you can't go after them anymore.
Okay. So I know you guys weren't focusing today on mortgage foreclosure cases, but of course, I know the consumer group does many of them, has for many years. So we will allow a mortgage foreclosure question, and here it is. In your experience, are judges in mortgage foreclosure court open to conducting mediation or settlement conferences? This questioner says they're trying to negotiate a loan mod to save someone's house, and they're not really that far apart between the parties. So any thoughts on mediation, seeking loan mods in mortgage foreclosure cases?
I don't have specific experience with a judge getting involved in the specific in a specific loan mod mediation negotiation. And I haven't seen that they're ready and willing to jump into that fray. There is in the previous mortgage crisis, there was a mortgage mediation program in the circuit court here that winded down in 2018, and I believe it is going to be started up again, but I don't know when, and I don't know the specifics of the program. Do you know, Dan Lindsay?
Yeah, the last time I asked someone more directly involved in putting the program sort of back together again, they said it was imminent. They still didn't know exactly when it was going to start. This is probably 2 months ago. Who knows? It may have started. It may start next week. It may start next month. But I think mortgage foreclosure cases in Illinois take a long time to go through the courts. So I would think any currently pending case, will overlap with, the inception of the mediation program. And so you'll be able to try to take advantage of it and ask for mediation. And the way it worked before, and I assume will in the future, or this new iteration, is it then gets referred to, somebody, a mediator who tries to get the two parties to work together. And mostly that means trying to get a loan modification. So hopefully that is or soon would be an option for a case like this.
I have found, I don't know who you are negotiating with, but I have found that filing a CFPB complaint about, about the case or what's going on with negotiations can help get someone with more authority to be communicating with you if you are just negotiating directly with the mortgage company. Consumer Financial Protection Bureau complaint about the negotiations or whatever is going on in the mortgage can sometimes help you get your negotiations kicked forward, or kick-started.
So actually, one of our audience members, it works for a housing counseling agency, who says that the mortgage foreclosure mediation program is now active. Their organization has not yet got any referrals. So of course, the housing counselors play a big role in the mediation program as well. And it sounds like it's just beginning, but that's good news for homeowners.
Yeah, I actually just looked it up online while we were here, and I see there's a phone number on the Circuit Court of Cook County website for people wanting to participate in the mediation program. I just didn't know if that was up to date or not, but worth a try.
Couple more questions. Here's one. One person's particularly interested in medical debt and says, I was under the impression there were some new protections for medical debt. Is that right? And, what is medical debt? Does it include dental and other forms of healthcare, or is it just kind of like getting surgery or going to the doctor? Can you talk about that a little?
So we don't actually see a lot of consumer debt cases filed for medical debt. There is a Patients Fair, I don't know the exact name. I think it's the Patients Fair Billing Act in Illinois that is worth looking at if you're interested in a consumer rights in relations to medical debt. I don't know the exact reasons why there's not a lot of lawsuits by medical providers. We do see medical debt that it's like very specific institutions that are sort of repeat filers, but like the big hospitals are not suing people for medical debt in Illinois. I know that it's a big issue in other states, but we see it a lot less.
Right, and I'll just add, I do think that some of the recent protections that maybe this person was referring to have to do with credit reporting and not reporting medical debt. So the debt may be there, but it may hopefully not adversely affect people's credit ratings as much. Well, I think probably we're out of time. It's 12:58. We've gotten to most of the questions. So I'm going to thank you all once again, both all the panelists did a great job and all the audience members. And thank you for all your excellent questions. And we will see you, hopefully many of you at the luncheon next week, and resume the series, the webinar series, the week after that. Thank you very much.